It starts with the builder, the contractor, and the supply house, all the way up the chain. We saw awful insulation, awful houses with shingles.
But that's a code enforcement issue, right?
It is, but that is what we typically go. One code enforcement official down there is not strange. He's very honest. He works with us. But he will rent out your house and the next day supervisor will go back.
Oh my gosh.
Tell us about the payoffs. I don't want to get into that. So we have to have some specific things, 4 or 5 things that we can enforce. But I'm thinking it's just so intrinsic. It's be something positive. You know, I've got a show coming.
Yeah. Well, yeah. Well, and I do think a lot of businesses conduct necessary like it is. And I'm not saying that we don't have officials taking bribes. I think there's probably more of that going on, not just in the construction trades, but across the board. Enough of them get caught that you know it must be more common than we think.
We'll see if we can make a little bit of
Well,
difference.
I think that.
This gavel. All right.
I want and there's
Don't
nothing
want it to
official,
pick
I'm
up.
sorry.
Just push it up. Ready to talk. Push it up. All right.
Bill.
Question. Good morning. It is 10:01, and we're going to start this ACR board meeting. So with that said, let's, if you would please put your phones on silent. And speak your name before you ask any questions for the members who are viewing to notify or see who is actually speaking. So with that said, let's do the roll call. Dolores Compion, present. Mr. Bender?
Present.
Mr. Stanley?
Present.
Ms. Lujan?
Present.
Mr. Morris?
Present.
Mr. Yelovich?
Present.
And we have 3 vacant positions, so we do have a quorum. So moving on to, I would like to take a minute to have a moment of silence. Today marks the 36th anniversary of the bombing in Beirut, where a lot of our service members lost their lives that day. So if we could just have a moment of silence, I really would appreciate it. Thank you. So the second piece is I'd like to thank all the staff members here at the TDLR for putting this together. Well, you know, I know we get to come up here and we get to sit down and all this, and we get to look at all these little fancy gadgets here. And so I really do appreciate all the hard work that they do behind the scenes, so we can have the honor and the privilege of coming up here and sitting down and doing what we do for not only our constituents, our public, our customers, and our licensees. So with that, I give a humble thank you to each and every one of y'all. So with that said, we'll go on to item C.
Chairman, board members, thank you. Doug Jennings, Assistant General Counsel for the department. Today we'll do a little bit of training on the Open Meetings Act, Administrative Procedure Act, and the Public Information Act. Now, you know, typically we do this once a year, but sometimes when we have turnover or significant legislative change, we like to go ahead and refresh the board. And so we have a new member, Ms. Lujan, and we also have a couple of legislative changes that I'll note. So I think this will be beneficial for everyone. We'll spend the meat of our meeting on the Open Meetings Act, and so the nuts and bolts. The purpose of the Open Meetings Act is to ensure transparent and open government. And this act, of course, as you know, requires meetings of governmental bodies such as yourself to be open to the public and preceded by public notice of the time, place, and subject matter of the meeting. The provisions of the act are mandatory, of course, and they're to be liberally construed in favor of open government. Thus, if there is a question as to whether or not a meeting should be held in public, let's hold it in public. Let's hold it pursuant to the act. A key concept, one of the most important concepts, is a quorum. A quorum is simply a majority of the members of the advisory board or the committee as fixed by statute. It says 5 for this board. Technically, it's 6. This board is a bit unique. It's got 2 ex officio, so non-voting members, which are the executive director and then the administrator of the chapter, which is the chief ACR inspector. A quorum of a governmental body, including a board such as yourself, must be present in order to take official action. Therefore, if a quorum is not present, you may observe, you may discuss, but you may not take official action. We have a quorum here today, so you are empowered to take action. Another key concept is deliberation. You'll see some notes here, and that just indicates how the statute has changed since the most recent legislative session. Deliberation means a verbal or written exchange between a quorum of a governmental body or between a quorum of a governmental body and another person concerning an issue within the jurisdiction of the governmental body. And a meeting, this is important to know, we'll harp on this, occurs any time a quorum of a governmental body engages in deliberation regarding public business or public policy over which the governmental body has supervision or control, or any time the body takes formal action. And then notice. And you'll see you've got an agenda in front of you. The Act requires advance written notice of the date, time, place, and subject of the meeting. We provide the notice in the form of an agenda, and we actually file that notice and the agenda with the Secretary of State at least 7 days before such a meeting. Going back to the point I made that a meeting can happen any place, at any time, keeping in mind that a meeting occurs when and wherever a quorum of a governmental body engages in discussion about matters under the jurisdiction of that body, can you ever meet in any setting without violating the Open Meetings Act? And the answer to that question is yes. Let's say you're at a party, social function, workshop, You're free to engage in conversation that's incidental to that meeting, but really we ask you not to talk about matters regarding board business. Don't engage in a discussion about anything pending before the board, for example, if you are meeting in numbers that might constitute a quorum, no matter where you are. So some key points to remember: always be aware of any situation occurring outside of a properly noticed meeting where you have a quorum of members present. And don't engage in substantive conversations relating to board business when a quorum is present and you're outside of an officially noticed and scheduled meeting. One more key point: beware the walking quorum. The walking quorum occurs when a group constituting less than a quorum meets, and the members from that initial group communicate those discussions to a group that would constitute a quorum. And I've got a good example here. Let's say that we have a 5-member advisory board, and 2 members exchange phone calls and emails expressing their thoughts on an upcoming rule change. They exchange some research, probably via email, that they performed regarding that issue. One of the board members subsequently forwards that email to 1 or more members of the board. At that point, we have engaged in a walking quorum by transmitting those materials, which were originally intended to be reviewed by less than a quorum to a full quorum, to a quorum of the body. This is the updated definition of the walking quorum prohibition. It's some word salad. I ask you to look at it on your own time, and we'll talk about it in practical terms. Essentially, here's what you're not to do. You're not to make a communication with a member with the intention that that communication ultimately reach a quorum of members. Doing so is a criminal violation. And we'll talk about how this can really manifest itself in the digital age. I think it's very clear from what we've talked about that something like a simple Facebook post, let's say the chairman posts a Facebook post about some industry issue, and 4 or 5 other members chime in commenting under that post. That's really easy. We see that's a violation because we see the members engaging. We can see the original post, and we can see all of the individual members chiming in. So we know that's a violation. Where it gets a little bit fuzzier is in with social media like Twitter. So we've got an example. In this situation, names have been changed to protect the innocent. Chairman Doe tweets a link to an online news article about an issue facing the electrical industry. Beneath the link, he writes, "This could fix our worker shortage." So board member Smith then sees that link and retweets it, and he shares that link. And along with that share, he states, "Thanks, Chairman Doe. Our board should take up consideration of this important matter." Then board member Jones sees Smith's tweet and replies, "We really need to look at Rule 101. Board member Williams also replies to Smith's tweet saying, "I agree, let's get this done." And board member Johnson responds to Smith's tweet with an animated image of the American flag and a thumbs up emoji. All right, I heard someone laughing, thank you. So we have what could potentially be an open meetings violation, and ultimately it's going to depend on the intention and knowledge of each member, but we'll see. Let's just assume for the sake of argument that everyone is aware of everyone else who has participated in this discussion. So we know in a 7-member board the quorum is going to be 4. So Chairman Doe is posting this link. He may or may not intend it to be disseminated to the full group. Board member Smith is probably in the clear. He's the 2nd member to weigh in. As we move down the list, we get in dangerous territory. So by the time we get to board member Williams, he really should know not to weigh in. And board member Johnson may be trying to circumvent the Open Meetings Act by being clever and posting his approval by showing an animated image and a thumbs up. Well, interestingly enough, the update to the Open Meetings Act specifies verbal or written communication, and I always thought verbal meant involving words, so written must mean something else. And so it would be my argument probably that posting an American flag and giving a thumbs up emoji would constitute written communication. So we have some issues here, and this is kind of a complicated setup, but it's just to clue you in that some situations that are very fuzzy could occur on social media, and to be wary of them. If you see a number of members engaging in a discussion like this on Twitter, probably stay out of it. If you think that a quorum if that message could ultimately reach a quorum. So some best practices to avoid some quorum issues. Don't meet in small groups to discuss committee business and then communicate those discussions to other members. Don't send emails or texts to a quorum of members regarding board business, even if you're addressing those emails individually. Don't create posts on social media about board business where there's a likelihood that a quorum of members could participate. And don't ask a quorum of members, even individually, where they stand on a particular issue, especially an issue that is up for vote, because that's called polling, and that is prohibited. We'll change topics a little bit. Let's move to guidelines for open sessions. So we talked about notice and the agenda. As you know, a board or committee is limited to discussing specific items on the agenda. This gets a little tricky when there's a public comment section of the meeting. Oftentimes you may have a member of the public come and ask questions or leave comments with the board. Because of notice issues, you are really constrained in your ability to respond to a public commenter. You can answer very simple questions, but if it's anything that would involve a substantive discussion, we really kind of need to put a pin in it, and note it for an agenda for a future meeting. And to avoid violating the act on the basis of insufficient notice, members should limit discussion to the specific agenda items filed with the Secretary of State. Avoid allowing discussions regarding specific items to wander off course into new issues. Don't respond to or discuss issues that are raised during public comment but which are not on the agenda. And do specifically identify items for future agendas and communicate those items to our staff. As you see, there are some penalties and remedies for Open Meetings Act violations. Any interested person, including the media, may petition the courts to stop actions taken in violation of the Act. And the Act specifically states that an action taken in violation of the Act is voidable. There are also criminal penalties for engaging in a walking quorum or circumventing the Open Meetings Act, which involve a fine of $100 to $500 or confinement in county jail for 1 to 6 months, or both. So you want to stay away from that. And we've got some resources. The Open Meetings Handbook from the AG is very helpful. All right, let's move on to the Administrative Procedure Act. We call that the APA. The purpose of the APA is to establish minimum standards of uniform practice and procedure for agencies and to provide for public participation and transparency during the rulemaking process. The APA governs a lot of our contested case processes, our prosecutions, but for the purposes of this board, we'll really confine it to rulemaking, since that's where your exposure will really come. A rule is a statement made by a state agency that implements, interprets, or prescribes law or policy, or describes the procedure or practice requirements of a state agency. I'm sure you're intimately familiar with the air conditioning and refrigeration rules, so you know what those are. The APA also says that a rule includes the amendment or repeal of a prior rule and does not relate solely to internal management. So our organizational chart is not a rule. It does not need to be placed in the TDLR rules. There are several sources for rulemaking. Legislative changes. When the law changes, we may need to change our rules to be responsive to that. Advisory board work groups also often propose changes to rules. Sometimes discussion in an advisory board meeting may generate an idea for a rulemaking. TDLR staff will sometimes propose rule changes. And every 4 years, there's a rule review process where the department will take a look at the rules and determine if organizational, structural changes need to be made. And there's also a mechanism called a rule petition. The rule petition says that an interested person may submit a petition to an agency requesting the adoption of a rule. And so you see an interested person could be a Texas resident, a business entity that's located in Texas, even a governmental subdivision. So we'll walk through the rulemaking process here, and you'll see, I'll walk through this whole chart, but you'll see the advisory board involvement is in the blue boxes. So typically when we are working on the rulemaking process, this board will have a chance to weigh in twice. There's kind of an exception, which we'll talk about in my staff report, but generally when we're engaging in rulemaking, first there's the idea for the rule, and then usually the attorney in the Office of General Counsel will draft the rules with input from other divisions of the agency. And then those rules will be presented to the advisory board for your consideration for an initial thumbs up or thumbs down. If the board gives the draft rule a thumbs up, we file the proposed rule with the Texas Register, and then the public will then have 30 days to comment on the proposed rules. After we receive those comments, our office, the Office of General Counsel, we will review the comments and determine if any changes need to be made, but we will also bring the rule and the comments to the advisory board a second time for your input, and that could result in recommending that the rule stay the way it was originally proposed, or make changes in light of the comments. So let's say that this board decides to accept a rule without change. You'll then recommend that our commission adopt the rule. We will take that to our next meeting of the Texas Commission of Licensing and Regulation, which will review the rule filing, the comments, and this board's recommendations, and decide whether to adopt the rule. If the commission decides to adopt the rule, we file a document with the Texas Register, which is a publication put out by the Secretary of State, and those rules will become effective 20 days after that filing. And this is just a very elementary look at the rule review process. We have programs on a 4-year schedule. We have to file a document called Notice of Intent to review those rules. The public also have a chance to comment, and the rest of eventually those comments will come before the board for your input, and then we kind of fit back into this diagram. And probably starting at the next meeting, we will probably start the discussion about our 4-year rule review for the ACR rules. Just a couple of quick notes on the Public Information Act. You've heard that called the Open Records Act sometimes. That's intended to allow each person to have information about the affairs of government and the official acts of government agencies, employees, and so on. And that makes all documents, underlined all, documents, records, and other information relating to official business open to the public, with a few exceptions. And public information could include any electronic communication on any device. And so if you have an agency-issued iPad or phone, anything relating to public business that you conduct on those devices is subject to the Public Information Act. So how does this affect you? Well, it's pretty easy. If you receive a public information request or some kind of correspondence from a member of the public asking for information, please send it as soon as possible to the Office of General Counsel, doug.jennings@tdlr.texas.gov. You can send it there, and I'll direct it to Open Records, or you can send it to open.records. You send that. We need it as soon as possible, and the reason is, as an agency, we have 10 days to respond to an Open Records request, and if we don't, there's some things that are not optimal that could happen. So we need those as soon as possible. And to just so you're aware, if there's any confidential information in those documents, there is likely a mechanism for that information to be protected. There are some exceptions from disclosure under the Open Records Act, such as dates of birth, email, some education, and protected health information. But I think the takeaway from this is if you receive a request, please let TDLR, please let Office of General Counsel know about it as quickly as possible. And if you'd like to do some other research into the Public Information Act, here's some light reading for you. Are there any questions?
Any questions? No. Thank you, Mr. Jennings.
All right, thank
Appreciate
you.
it. So before we move on to the approval of the minutes, I am honored and privileged to announce our newest board member, Ms. Floyd Lujan.
Thank you. Thank you for the opportunity.
All right, so let's move on to item D, approval of the minutes. So, team, there was a slight adjustment this morning. We happened to leave Mr. Stanley's name off the minutes from our last meeting, so that was added. The changes should be reflective in your documents. So, can we get a motion to approve the minutes?
Okay, make a motion.
Second?
Second.
In favor, say aye.
Aye. Aye.
Any nays? Motion carries.
I'm sorry, Mr. Chairman.
Mr. Bittner was first. Mr. Stanley was second on the motion.
Thank you.
All right, do we have, we move on to item E, any public comments? No public comments, all right, we'll move on to staff reports, item F.
Good morning. I'm Lisa Hodak, the licensing manager. And my report. So the contractors for fiscal year 18 and 19, the numbers are fairly consistent there. The registered technicians, about the same. We did see a decline in the population for certified technicians for fiscal year 2019. However, overall, we did see an increase in the population, and we're now at just over 48,000. Are there any questions regarding the licensing statistics report?
Any questions, board? None at this time?
None.
Okay. Also, just wanted to mention the new requirements in regards to House Bill 3029. The number of applicants who were certified that applied for a licensed contractor, we had 3 that applied, and we actually issued 1 license.
And that covered, Dolores Compion, that covered what time period?
That was, it should have been, well, that was just a little over a month, because that started September 1, 2019.
Okay, a little over a month. Thank you.
And then for the certified technicians who took the exam, we had 79 that applied, and we've issued 8 certified registrations. And that's regarding the last bill that was filed, House Bill 3029.
Dolores Compion, any questions from the board? Thank you so much.
And that concludes my report. Thank you.
Good morning, advisory board members. My name is Tuan Nguyen. I'm the customer service manager for this program. So before I go into the statistics for this program, I just got some updates for y'all. So since the last time we met back in June, customer service division has moved over here to the 2nd floor, so we are now located at our North Campus location here on the 2nd floor. The other thing is we also updated our contact center software. That was in order to increase our efficiencies and also allow us to get more detailed reports on what type of calls come in. So we're looking forward to how some of those reports are going to pan out, and also be able to get more specific details and help us a little bit more with our analytics. We also moved over to our web forms introduction for emails. So on the websites, people used to have to we used to refer to our customers with the industry email, the cs.air.conditioning. We now have a web form that if a customer just wants to send an email for AC related, the web form is just like an email. It's more secure. It allows them to put attachments on their message to TDLR. And then they also are able to identify the industry. But the most important thing is we are able now to identify customers on who they are. And also customers are no longer sending in incorrect emails. We used to have a lot of inquiries when people send in misspelled emails and things like that. As long as they're using the web form, it's always going to go to customer service, and we can always respond. The other update I have for y'all is it wasn't just us in customer service, but as an agency, us, licensing, GC, enforcement, RPM, we were able to help update the certificate of insurance form for air conditioning and multiple other programs as well. And the biggest benefit of that is a lot of our emails, inquiries, and also by mail, people were sending in certificate of insurance on the Core 25 form. Now they can actually fill out TLR's version. The great thing about it, as long as they are filling out the fields correctly, that's all they need to do. They don't have to guess which fields need to be filled on the Accord 25. Now it's TLR's own version, and the exact amounts for insurance and everything is on there. So that has helped us tremendously in some of our emails. We don't get a lot of those inquiries as much anymore, and we're hoping the population continues to use that new form. That's all I have. I'm going to statistics now. So since the last time we met back in March, our statistics been roughly very similar to last year's, except for July. We have an average of about 2,300 contacts. July was just a little bit extra on our emails in terms of we've been running our reports a little bit in terms of we used to have filters for the extra marketing and stuff like that, and those are now coming through, and we just counted them and we started removing some of them for August. The other thing is customers were kind of asking in about license status updates and a couple of other inquiries. For the most part, it looks like it has went down in August, and we were able to respond to customers with that. Other than that, if you have any questions for me, I'll be more than happy to answer them.
Dolores Compion, I do have one question.
Yes.
And just kind of looking at the calls, we still see quite a number of calls coming in versus emails,
Mhm.
with the exception of July.
Correct.
So what do you, in your opinion, you may or may not have that information, but what prompted that spike?
So for the amount of, are you talking about the calls or the emails portion?
Well, actually both. So we're looking
Oh,
across
got
the
it.
board
For
month to
just July.
month. We see July seemed to be it's because you think the weather got hotter and more complaints came in, or just what?
We definitely probably had, I wouldn't know the exact details. The bulk of our phone calls that actually leads to more phone calls is application statuses and whatnot, and we are trying to get more proactive about it to reach out to customers so they don't have to wait in the queue. The emails portion, we couldn't get, I tried to compare it to the licensing data, but we couldn't really see a big trend. It's just an odd spike, but it wasn't totally out of our spectrum. I would say compared to last year, it was the opposite. In March, we had 2,700 contacts around that time, and this time it seemed like it just fluctuated to July instead.
Okay, thank you.
Mhm.
Any questions from the board?
I have one, Dave Yelovic. You take calls from it, like you say, about application status to complaint calls.
Yes, everything.
Is there maybe a way in the future to get maybe another graph or something showing what those calls are about?
Yeah.
Whether a complaint, what the complaint is about not cooling, or the contractor was rude, or about,
Yeah,
their registrations, just so we know where all these numbers are really
Coming
applying
from.
to.
With the new system that we have, that's what we're trying to build up to. We're trying to get more specific in the data of by programs, like for AC, what exactly are they calling. We won't be able to get to exact details, but at least like complaints,
Mhm.
application updates, where's my license, things like that.
And
So-
that'd be helpful. Thank you.
Mhm.
Any other questions? Mr. Nguyen, thank you so much.
No problem.
Move on to enforcement, number 3.
Good morning. My name is John Medlock. I'm a senior prosecutor with the Enforcement Division. A few things to go over with you today. The first is our current projects is back in July, the Commission of Licensing and Regulation finally approved the new AC penalty matrix for the new member. Essentially what the penalty matrix is we take all the laws and rules and we put them into kind of a class system, like Class A, B, C, and D. Class A being the least serious violations, and Class D, and it kind of binds, what the prosecutors can do as far as different violations when the complaints do come in. It kind of standardizes across the board for the for each one of our different programs have one of these, so that we know if there's a violation, this is what the action we're probably going to take. So that was finally approved, and so that's gone into effect, and we're using that now. A lot of the updates on that were some of the new certified technician with that House bill that came in that so we had to add that stuff into it. Going further, in September, we had one of our investigators meet with the ACA group in San Antonio, or I'm sorry, in the Houston area, and he basically just kind of went over kind of some of the new laws and rule changes and kind of the updated with the certified technician, kind of letting the folks there know that that's out there, that that's an avenue for maybe some of these technicians to kind of, if they don't want to go to the contractor route necessarily, they can go to this in the meantime before, going into that contractor route. One of the big things we always do is stings. In this past June, we had one of our big sting down in San Antonio area in the first part of June. It was part of the national stings that they have across the nation for the building and mechanical trades. So this one was down in San Antonio. They spend a few days down there, and then usually we always try to work in conjunction with one of the local news stations. So they'll build the contacts, and I believe in this one they had over 150, maybe over close to 200 contacts that they tried to make, and got about a third of that to come out and actually give bids, and this one was a combination of both AC and electrical. So they came out there and give bids, and then usually they'll try to get 1 or 2 or 3 people to come back with the news crew and kind of do that, hey, do you know that you guys need a license type thing, and they'll promote it there. So that's always something that's usually very successful, and we like to do it. And it's not the only sting we do. We usually do about maybe sometimes 2, 3 stings a year, but this one in June is the one we always typically do. Going through some of the case highlights real quick. The first one, there are 5 different cases that we'll be talking about. The first 2 are agreed orders. The second 2 are default orders. And the 5th one is kind of a new one that we've been bringing to you guys. It's some of the criminal history reviews, just to kind of let you know that there is a kind of a different subsect of cases that we do handle with the criminal history reviews when people are applying for licenses. We do review everyone's criminal history, and there are certain disqualifications or crimes that if you've committed that are directly related to the occupation that we typically will seek to either deny the application or revoke the license. So that'll be the 5th one that I'll talk about. But in the first one, Chris Alban, in this case, it was an agreed order. He actually, in this case, the company ran a manual J, and it said that in this case you need about a 4-ton system. I believe it was downstairs and a 2.5-ton upstairs. Excuse me. But when they went to do the installation, they put in a 5-ton and a 3.5-ton. So obviously it was an oversize for what the manual J had run. Once they discovered that, they tried to go make it right with the consumer, and they tried to go out there and make some corrections. However, I think the consumer was fairly upset at this point in time, and so they had engaged a lawyer and engaged in litigation, so they weren't really allowing them to go back out there and make a whole lot of corrections. So in this case, we assessed a $1,500 penalty, and Mr. Alban has paid that entire penalty. The second case is Chase Carroll. He was actually a registered technician, but he was performing unlicensed refrigeration work on a walk-in cooler at a restaurant there in the Pflugerville area. And so he was assessed a $3,000 penalty for essentially, I call it under-licensed work, because he does have a license, but he's not the required contractor's license to be performing the work, because he was doing it all himself, the advertising, the bidding process, which requires that contractor's license. So it wasn't truly unlicensed, but that's the way statute reads, is that it's unlicensed work, but it's kind of an under-licensed thing. He was assessed a $3,000 penalty, and he did pay that entire penalty as well. The next case is a default case, and essentially what happened in this case is the respondent did not respond to any of our questions or any of our notifications that we sent out, and so one of the things is if when we don't get that, we'll just go forward with a default order, and sometimes that's kind of where it ends. We don't hear communications. This one's a little bit unique. So Mr. Fierro was installed. He was unlicensed as well. He was building a walk-in cooler for essentially it was a wine cellar, and it was a fairly large wine cellar that needed commercial refrigeration, and he was performing that work. He didn't respond to any of the enforcement's notifications. We send out a notice of alleged violations, and if you don't respond to that, then we'll send out a notice of intent to default, and if you don't respond to that, then that's when we'll go forward with the default process. So he didn't respond to any of that. The default was entered in July, but rare as it does happen, sometimes these people will come back and see the light, and he has actually gotten in contact with our general counsel's office and then gotten into a payment plan to pay on that default order, and as he's paid $1,250 of that $4,000 penalty that we did assess against him. So it doesn't happen a lot with our default orders, but it does occasionally happen, so we kind of wanted to highlight that one. The next case, Daniel Jimenez, that's more of the classic kind of a default order. That one was entered in August of 2019. He again submitted a proposal for a 3.5-ton 16-SEER system, and the total amount of the proposal in the bid was for $6,500. We sent out the notice of alleged violation, sent out the notice of intent to default. He responded to neither one of those, and so we went ahead and entered into that default order. I checked just recently, and so the default order was mailed out to him, and just recently, and we got the mail back saying that it was unclaimed. So typically at that point in time, if after we send out the default order, What the department will do is we'll attempt some debt collection on our own, either through some letters that we'll send out or even with a third-party vendor. And if the amount is high enough, we'll refer it over to the AG's collections office for them to try to collect on some of those debts too. So that's kind of some of the things that we try to do with default orders. We don't just let them kind of sit there and lie. This last case, again, like I said, was a criminal history. Again, we review anytime that you apply for a new license or you go to renew your license, we do run a criminal history check on you. And each one of our different programs have criminal conviction guidelines that we kind of go against. So in this program, we care a lot more about assaults, burglaries, theft, because those are some of the issues that may surround, the AC industry. It's like theft of copper wire, burglary of habitations, because you go into people's homes, there's a chance to steal these things from supply shops or even homeowners. So if you have one of those convictions on there, we're going to probably take a really close look at it, see when it occurred, how many times it had occurred, because obviously if you commit one crime, there is a chance you may commit a second one in your history. So we take into account all that, and then we have a couple attorneys on staff that will review those and make those determinations whether or not to either deny the application or go ahead and revoke the license if it's current. In this case, Mr. Honey was revoked by what we call operation of law. So there's a provision in the Occupations Code that essentially, if you go into prison, not like a county jail, but like an actual state prison on a felony level conviction, or you have some kind of felony level community supervision revoked, the day you enter, if you have an occupational license, it is revoked by operation of law. Now, typically, if you have a license application denied or you have a license revoked by us, you have the opportunity to appeal that to the State Office of Administrative Hearings and ask the judge, hey, based on some different factors and circumstances, that maybe I can still keep my license. Well, in a situation such as this, the day that you enter into that state facility or federal prison, it's revoked by operation of law. You don't have a right to get back that license or ask for a hearing. It's just automatically revoked. And so that's what happened here with this gentleman, and that happened in March is when he actually entered that facility. And so he'll have to actually sit out for 1 year in the AC program before he can go back and get his new license. So March of 2020 would be the first time he could apply for a new license. Now, if we look at some of the new statistics, we kind of added, so for the members who have seen this report in the past, this is actually a lot more of the statistics, because this is kind of what you guys wanted to see. So we kind of broke it down in columns, the first column being, this is all the sting activities, the next column being ACR program as a whole, and then there's a percentage of all the programs, and then the last column is all the programs in TDLR that we regulate. So as you can see, in fiscal year 19, which our fiscal year is from September until August, we opened 32 sting cases in the AC program as a whole. As you can see, we resolved 34 of them. The reason that number overlaps is because sometimes we had the sting operation this past June. Those resolutions might carry over into a fiscal year 20. So that's why sometimes those numbers don't exactly match up. But you'll see that we have the percent of cases that did not result in disciplinary action. And that could be for a couple different reasons. Maybe we issued a warning. We don't consider that a disciplinary action. We just said, hey, we think you did something wrong here, but you've made some corrections. So that's why that number is a little bit higher, because there weren't, if I remember correctly, there were about 28 cases total in the AC, and about 15 or 16 were actually cases that resulted in some sort of disciplinary action. And so that's why that number is a little bit higher, because a lot of them, we actually issued some warnings on some of those cases. Again, the flip side of that is 59 did result in disciplinary action. There were 20 final orders in sting cases, and with $33,000 that were assessed in penalties, which is a high amount. And rare as it is, sometimes, so a lot of times with the sting activities are unlicensed people, so those are sometimes typically harder to collect from the unlicensed persons, because there's not really an incentive. There's no license tied to the work that they're doing. So sometimes those end up in default orders a lot of times. But in this case, we actually did collect $4,300 worth in some of those sting penalties. The next column, I'll just start kind of on the bottom, is consumer restitution, which is something that you guys kind of wanted to see. It's something that we've kind of been doing for the last several years, is tracking this number. We'd always been kind of doing it, but now we're actually kind of tracking that number so we can present that out. One of the things that as a prosecutor we'll get a case. There might be some kind of indication either from the respondent or maybe from the complainant, and usually it's from the complainant, like, hey, I just want my money back. Well, there's nothing in our statute or rules that we can order that restitution to occur. But in situations where there may be some kind of a meeting of the minds where the respondent might be like, you know what, I just want to make it right. I don't want to pay a penalty. I'd rather just pay the person, and vice versa. The person's like, hey, I don't care if you assess a penalty. I just want my money back. We'll try to facilitate some of those things. And so that's why we've been tracking that number. And we've actually been really successful in the air conditioning program to achieve that by, you know, as you can see, $74,000 in fiscal year 19 alone, which was a quarter of all the restitution in all of our programs. And granted, we've got 41 programs now. So if you can think about that, this program does have a lot of willingness to make things right, which is something I think we definitely want to highlight. And yeah, we would like everybody to do everything right on the front end so that I don't see those complaints, but at least there's the willingness in this industry to say, you know what, something did go wrong, you know, let's make it right, either by refunding it or having paying a third party to come in there and correct those situations. So I do think that that's something that we should highlight and point out. Again, all the other numbers are basically about what this program has been running over the course of since we've had it here. You know, about 8 to 9% of all the open cases, you know, in TDLR come from this program. You know, about 8 to 9% are resolved, you know, in this program. And again, you know, final orders, the amount of collections, that all has basically kind of been running true. So with that, if you guys got any questions, I'll be happy to answer them.
Got one, Dave Yelovic. When we get down to these big, about $1.6 million for all of TDLR, what
Yes.
happens to a license holder who's assessed a fine and he doesn't pay?
So if it's somebody who has a license, one of the things that we do in addition to once that, either if it's an agreed order, a default order, or even a commission order, one of the things that enforcement will do is once that order is signed, we'll put in what we call an enforcement hold. And that's kind of a key to our licensing division, is that when the next renewal period comes up, is that you won't be able to renew that license up until you make either some kind of financial arrangement with us to make that payment, or you pay it off in full. So we kind of almost prevent you from renewing that license until you've made some kind of, you know, either start making payments again, or you will pay that payment in full. The other thing is if they are on a payment plan and they've stopped making payments, we'll open up a second case to seek to revoke that license and just go ahead and then that sometimes will spur them back into action to start making payments on the other that financial arrangement.
Thank you.
Dolores Compion, I'm going to go back to Mr. Albin.
Yes.
So I know there's a lot of idiosyncrasies to this, and so I'm not privy to that, but I just kind of had a roundabout question where it goes, Mr. Albin tried to communicate with the complainant after discovering improper installation, and so it appears that he tried to do the right thing, and we assessed an administrative penalty anyway?
Right, yeah, so there still is a violation there. I mean, because they installed the wrong size system, and there were still a lot of issues that were going on at that home in particular. He did try to communicate and try to go in and fix it, but at that point in time, the consumer in this case had retained counsel, and they were seeking private litigation against him. So typically, if they're, again, we have a penalty range, and this would be what we call a mechanical integrity type violation, Class C. The range in that is anywhere from $2,000 to $5,000, and or a license sanction, or I'm sorry, and a license sanction of up to, well, this was actually under the old penalty matrix, so it was an and or a license sanction. Now it includes some sort of a license sanction, which could be a probated suspension all the way up to a revocation. So we have a little bit of flexibility in that range. So what we did in this case is, typically when we have a mechanical integrity violation, usually that means that either the consumer's out a lot of money or it's going to cost them a lot to fix it. And a small penalty sometimes is almost cost of doing business. Well, in this case, and so typically we go like about a $4,000 penalty in those kind of situations per violation. In this situation, we recognize that, yes, there was something that was wrong that was done, but at the same time, he did try to make corrective steps by contacting them as soon as he realized, oh, wait, we put in a larger size system than what our Manual J called for. But because the consumer did not want to essentially reciprocate letting him come back out there because I'm assuming he lost trust in that AC contractor. We made the evaluations like, this is a violation, yes, but we're not going to penalize this guy at the range that we normally probably would penalize somebody. So we went on the lower end. We went with actually with the $2,000 penalty, and then we settled at a $1,500 penalty.
Thank you.
Jerry Bittner is on Mr. Alban as well. It doesn't indicate how the error was discovered.
It was they started having a lot of issues, and when they the homeowner called him out there, they started realizing that they weren't getting the right kind of cooling in the room. It wasn't, for whatever reason, it wasn't cooling correctly, and it may be because the system was oversized, that they called in a second contractor, and then that's when it was discovered. It's like, your system's too large for your home.
So it was the result of a complaint.
Yes, yeah. All the cases that came through are results of complaints,
Thank you.
except for the criminal history one, which is one that we kind of initiate because, in the renewal process, that's when we run the DPS, and then our attorneys review that stuff. But the other 4 are direct results of complaints.
Thank you.
Any other questions? Thank you, sir.
Thank you.
Appreciate it. Item number 4.
Good morning, Chair, Advisory Board members. My name is Rebecca Adamus. I am with the Education and Examination Division. Welcome, Ms. Lujan, to service with the Texas Department of Licensing and Regulation. We welcome any questions you may have. I have left my business card there with you if you have any questions for us. I'd like to start off our report just by mentioning, since our last meeting, we did meet with the Exam Review Committee to discuss poorly performing items and also to kind of regroup to get ready for the re-referencing of the latest Modern Refrigeration edition. We'll start that starting in January 2020. Shortly, you'll see on the website as well as a listserv will go out that we're looking for volunteers to assist us with this exam review process. We're always looking for folks in the industry to come and give us a hand here in Austin to reference the examination to make sure that we are, holding this exam accountable for making the proper assessment to the candidates. One of the things I also wanted to give you guys an update on with the statistics, especially for Ms. Lujan, what you see in our statistics as far as the examination, they're attempts. It's not specific individuals, but these are attempts at each individual examination. So when you're taking a look at it, just kind of keeping that in mind when you're looking at the statistics. And I'm here to answer any questions any of you may have.
Dave Yelovic, I just had, when I see these numbers, I see these and I look at the bottom and, the percentage passing, I guess, is always, well below 50%. And I know if this was a public school system, we'd be asking what's wrong with our education system if only 30 or 40% are passing. So the question is there something in the schooling or the curriculum or something? Why is it, over history here for years and years now, it's always between 30 and 40% pass? What's happening?
What we find is, the pass rate is the pass rate because this is an assessment for licensure. So it's a little different than if we're taking an examination for, an MCAT or something similar to that. This is, it's going to make the assessment based on the reference material, and it's this, the preparation. We write the examination according to, all the reference material. We use, industry language, nothing out of the ordinary. It's all about preparation, and, we encourage students, or candidates, take your time, make sure that you meet with your instructors, and that additional requirements that, if you need a little extra time, get with the proper training, because that's the root of everything is, proper training and then preparation for the examination. We have that candidate information bulletin that's out for the candidates to show the content outline, where it's going to give them a list of what questions and what topics are going to be there for them to kind of help them prepare a little more. And I think that's where we're struggling a little bit, is just in the preparation. Getting, and maybe that's something that we meet with our subject matter experts and get a little more, take the temperature of, because they represent this throughout the state. They're not just from Austin, they're
Right.
from all over the state of Texas. And get what their feel is, what do they feel where the issue is.
Do we have any numbers, or can it be extracted from this? The schools that these students come from or do most of their training from, is there any way to say these students from this school seem to pass better than these people?
We do not have that information because we don't regulate them specific. We don't have any schools that have currently applied for the certified technician course. So that would be one that we could track, but we don't regulate the other schools that are offering this additional the additional courses.
Is there a way to survey applicants when they do pass and say, hey, how do you feel about your training? What school did you attend? What, do you feel like they served you? Something like that, just to
They're
get that.
given when they take their examination, it's an optional survey, but we can definitely look at, perhaps when they submit an application to take the examination, we can put that as part of an additional little survey there. It's something we can look into for you.
Thank you.
Dolores Campion. So, in kind of tagging along with Mr. Yelovich has mentioned, so we look at a 32% rate, and so I think I'm looking at this slightly different. Out of the fail rate, how many of those are repeat test takers, if we could track that?
We could get that information for you. I don't have it off the top of my head, but we can definitely have those reports for you where in your next advisory board meeting, we can separate that out for you if you'd like.
I think that, and it's just my opinion, just sitting out here just thinking out loud here, is that out of the 142, if we discovered that 75% of that was a repeat test taker.
Sure.
Basically, in my opinion, he's just taking a test and hoping that it'll pass, and because he knows he's going to have another chance,
Sure.
and another chance, and another chance, and sooner or later, you kind of run through all the questions for the most part. But if we could kind of add that to the statistical
I
data
can
here,
definitely do that.
I think it'll kind of maybe explain the pass percentages a little bit better.
And Mary Winston, TDLR, Chairman Campion, and Mr. Yelovich, very good questions, because I know that our E&E team, Ray Pizarro isn't in the room, but they're always trying to drill down on the psychometrics of testing and the training and the subject matter experts, and just requesting these 2 extra bits of information are more pieces to that puzzle.
Any other questions for the board?
Yes, Jerry Bittner. Has there been any metric examined with respect to polling the people that take the tests with respect to the amount of time pressure that they feel? It's always been my observation that people who may have otherwise properly prepared for an examination do poorly, or much more poorly than they might otherwise had they been given more time to complete the exam. And I'm curious as to whether or not there's any polling question, exit polling questions to the test takers that ask, do they feel that they would have performed better had they been given slightly more time for the examination?
We don't have an exit poll question per se. However, each examinee is, through our third-party vendor, they track how much time they're given and how much time each examinee is taken on their respective exam, whether they've taken the full time, whether they've taken, they maybe did it in 45 minutes instead of maybe the 2.5 hours or 3 hours that were allotted. That is something that I can provide also on our report to kind of give you an idea of whether or not they are using the full allotment of time for the respective exams, if you'd like, sir.
That would be very interesting. My suspicion is that almost everyone takes the full amount of time and wish they had more.
And it has been, in some of our other industries, I've noticed they don't. And it's because they skip through and they choose not to answer. And it may be, as you said, Mr. Campion, they're just coming in to get a feel of it. The great thing with the fact that we do so many exam review sessions is our item pool is ever changing. We're always beefing up that item pool, so they're never going to see the same exam twice, even if they take it 50 times, because we're always doing this maintenance on the examination pool. But we've asked these questions when we're sitting down with the subject matter experts, determining the time allotted is how long are they taking on these items? How long are they taking on this examination? And our psychometrician, she can provide that information, and that kind of helps us determine the time allotted for the respective examinations. And I found that surprising. In some of our industries, they are not taking their full allotted time. And we can definitely research that for you and have that for you for our next meeting.
Great, thank you.
Of course.
Any other questions? Ms. Adams, thank you so much.
Thank
Hopefully I
you.
pronounced your name correctly.
You did, thank you.
Moving on to number 5, the regulatory program management division.
Well, good morning. I'm Bill Weatherly. I am the program chief for the air conditioning refrigeration. And I want to welcome our new member, Ms. Leon, as well. Glad to have you here. And just for your benefit as well, I'll just give you an example of what my duties are as program chief. I'm looked at here as the subject matter expert, and so I provide support to other divisions and like licensing and also enforcement, a lot to enforcement. Let's say the enforcement was talking about things that come in that are mechanical integrity. Usually that's when we help the investigators with that. It's easy if it's unlicensed activity, something like that, they can take care of that. But if it's mechanical integrity, it usually comes across my desk and I help them that way. Then also, if a case goes to the SOA board, which is the State Office of Administrative Hearings, I can also be called as an expert witness in that. The other thing, that the fun part, what I like to do is public outreach, and we want to, basically our constituents are not only the public and the consumers, but also our licensees, and love providing help to them as well. Well, what I want to do today is just kind of go over a summary, a kind of a highlighted summary of what we've done since the last board meeting here. First thing I'll talk about is Rebecca just talked to you about the exam review, and also want to give thanks to Mr. Robert Stanley here. He does double duty for us. He's also a subject matter expert in our exam review, and thank you, Robert, for that. And as she said, we also needing some more subject matter experts from our licensing group for that. But in that exam review, just touch on that just a little bit. We had that back in April. I participated in that as well. And all the questions on the test come from our resources. That test is 4 hours long, 120 questions. They're multiple choice, and every question on the exam comes from a paragraph in one of our resources. So one of the ways of taking the test is to bring the resources. It's open book. You bring the resources with you, whether it's the International Mechanical Code, it's the Modern Refrigeration. And if you're good at looking at the index and the table of contents, and you can flip through and you can find that question. And that's one thing that in our exam review we do. When they're looking at the psychometrics, they're looking at maybe here's a test question that only 10% of the people got it right. Well, that's not going to be on the test again because the computer's not going to put it up there. Or it was 90% got it. So we're looking at was this question too hard, or not hard enough? And so we kind of go through it that way. And it was a good question about the I think, how long is the test? Do we need more? Do we need more time? And I think that's something we could definitely look into. But years ago I took the test myself, and I'm still maintain my license, and I do the CEs every year. Just I do no public contracting. That's what it says on my license, but I keep it up. But it was a tough test, and it took me the entire 4 hours. I mean, I think I got finished within 15 minutes left do I push the button, you know, and because then the test is over when you do that. But it's all there, and the schools that they go to, exam schools, that mainly what they teach is how to take your reference materials and look that up fast and do some practice tests. Also, as far as Mr. Yelovich, you mentioned, you know, schools and prep classes, and you know, a lot of these applicants, you know, get a 2-year degree in air conditioning, you know, or you could go to a 1-year school. But there's also the other path is just on-the-job training. Some of them just work under a licensed contractor and they don't go to school at all, and it's that way, you know. So it's a lot of ways to get your license that way. So next thing, I just want to tell you about I was a guest speaker at the City of Austin's Energy Spring Residential Contractors meeting. That I was glad to go and do that. You know, Austin is their own utility. Austin Energy is owned by the City of Austin, and so they have a big incentive to keep the energy down, so they don't have to build more power plants and that kind of thing. So they have a lot of rebate programs for the residential contractors. So every year they invite the residential contractors in and talk about the rebate programs for installing high efficiency equipment. So they invited me there to just talk about TDLR, the law and rules and that kind of thing, and enjoyed that because there were 75 to 100 contractors, and they were right there, and I was able to talk to them, and they were a captive audience, so that was very good. And anytime along the way, if you want to ask me questions, just stop me and we'll talk about it. Also participated, several of us in the RPM division, participated in a disaster course. It's called When Disaster Strikes. It was put on by the International Code Council, and it's more or less you would be a second responder, say like Hurricane Harvey, something declared disaster. You would be a resource. We could go, you know, in the air conditioning program, I could be a resource to code enforcement, and then also do damage assessment, and that's what they taught us in this course. Also was invited to talk with the Texas State Association of Plumbing Inspectors, and might find it interesting that I went, you know, as air conditioning program manager, but in some of these smaller municipalities, the plumbing inspectors do other things too. They inspect electrical and air conditioning just because there's not that many people, and so they wanted to, you know, to hear a little bit more about air conditioning and TDLR. So we did that. Just, you know, cross-trained a little bit. Also, you know, we work with enforcement, but the investigators in our enforcement division do a great job. But they are investigators and they're not subject matter experts, but they do a really good job gathering the information. And so what I was been trying to do over the last year is give a little cross training. So I'm not going to teach them air conditioning, but if they know a little bit more, you know, about what they're talking when they're talking to a contractor, you know, they're more prepared. So one of the things I did is we do most of the cases that come in are residential. And we don't see a lot of commercial. I have a lot of commercial experience when I was in the industry, so I came up with an idea. This building here, Twin Towers, is a good example of a commercial building. Mr. Jerry Bittner is in the commercial business. He would kind of know this too, but there's centrifugal chillers and cooling towers and things that you don't see, you know, in a residential situation. So I worked with the building engineers here, and I got all the investigators together, and we had a walking tour. You know, this is a centrifugal chiller, this is a chill water pump, this is a built-up air handler, this is a cooling tower. This is how it all works together, and I think they appreciated that, just seeing something that they don't see all the time. We did go to one administrative hearing as an expert witness this year. I have an associate. He is a program specialist and a subject matter expert as well, Mr. Jeff Nielsen, and he was involved in the case and testified, and so that was back in July. Mr. Nielsen also went to a meeting of the, the Plumbing, Heating, Cooling Contractors Association, PHCC. He represented us there at that annual convention. And then an interesting Usually when I go out on to talk to the public, it's I tell them about TDLR, and we go over law and rules and maybe some tech tips. But the South Texas Fire Inspectors Association wanted me to come down. That was in Weslaco, who went down. They wanted an all-day school, and they wanted it for because they're the same way. I talked about the plumbing inspectors. In the smaller municipalities, the fire inspectors do double duty as well. So we put together a little expanded program, kind of like taught a class, and also they brought a representative from Texas A&M Engineering Extension Service there, TEEX, and they evaluated our program, and they actually gave them, I think, 2.5 CEUs for that, and it counted toward their continuing education as well. So we were glad to do that. That wasn't something we put together, but they just did the assessment on their own, and we met some good people down there. I also attended the monthly meeting of the Texas Air Conditioning Contractors Association in San Antonio. Met the new Texas State Executive Director down there. They have a new director for Texas Air Conditioning Contractors Association. And just wanted to reiterate some of the things that we do. You know, you've got my cards. You can call me anytime if you have questions. We, on a daily basis, I answer calls from customer service as well. Something will come in and they won't know how to answer that, and they'll call me. And I try to answer all those questions from customer service before the sun goes down. I try to be pretty responsive to them so they can get the information back out. They were the first line of folks call TDLR, so we want to get them a good response pretty quick. So, and the last thing I have is just upcoming at the end of this month. I'm going to El Paso. Kind of put together a collaborative down there with the city of El Paso, and they're going to sponsor it. But we're going to talk again. I'm going to give a presentation on law and rules and TDLR and some tech tips, but also collaborating with SPEAR. And if you don't know, not familiar with them, it's an acronym, but it's a South Texas Partnership for Energy Efficiency and as a resource. And they have a lot of good training as well. So I'm going to team up with them. Also going to the representative, the executive director for Texas Air Conditioning Contractors Association is going to come as well, and see if we can get a little more interest. They want to get a little more interest in a chapter down there in El Paso. So Ms. Lujan, I have a flyer for what we're going to do at the end of the month, so I'll let you see that. If would love for you to come there as well. And like I say, it's sponsored by the city of El Paso. So that's about all I have for you, but I'll answer any questions that you might have.
Board members, any questions?
None?
Well, thank you very much.
Mr. Weatherly, thank you so much, sir.
You're welcome.
Moving on to the executive office.
Good morning, Mary Winston again. I'm going to be giving the executive report this morning. We're going to start off with some personnel updates. Carla James, our current Deputy Executive Director, has announced that she is retiring. So our Executive Director, Brian Francis, and several staff members conducted interviews, and because of TDLR's growth, expansion, evolution, whatever you want to call it, Carla likes to say we had to get 2 people to replace the one of her. We know that Mike Aris-Mendez joined us. I think we got to announce that at your last meeting as the Deputy Executive Director, and it was he and Carla. Now, Carla has been split into the persons of David Gonzalez, new Deputy Executive Director, starting December 1, and Christina Kaiser, also new Deputy Executive Director. They're coming from directors of David, RPM, and Christina Kaiser, the Enforcement Division. So welcome. You will know the faces. You've seen them or have seen their team's reports because they've both been here for quite a while. And David is just all things. He's done several summits, all things RPM. So very excited for that. And Christina, I love her. I worked for her in enforcement when I first got here. So we really couldn't ask for 2 better people to take the place of the one Carla. We will miss her, but we welcome the change.
Dolores Campion, yeah, I did notice a subtle change. The tie was a little different this time, so I knew something was amiss. So, no, congratulations.
Yes. Also, the next thing we have on B is update from the 86th session. I'm going to defer that to our Deputy General Counsel because next he's going to talk about some rulemaking related to that. But wanted to talk to you about the sunset review process. I don't know if everyone knows that we are in the process of that review. Sunset Advisory Commission is an agency of the Texas Legislature that evaluates state agencies and makes recommendations to the legislature on the need for, performance of, and improvement of the agencies that are under review. Basically, the sunset process is an assessment for the continued need of this agency or the regulation. The Texas Commission of Licensing and Regulation and the Texas Department of Licensing and Regulation are currently under review by the Sunset Advisory Commission during the Sunset's 2020 and through 2021 review cycle. And we have several people, you've probably seen them over there furiously writing notes. Wave, hi. So they're great, but they become part of the family because we're in the middle of our self-assessment. Actually, we provide the self-assessment, and we've been doing several presentations for them to kind of better understand how we do, and at the end of the process, they will make a recommendation pertaining to the agencies, well, several, effectiveness, growth, need, so forth. Kind of like when we go out for strategic planning, what we do well, what we can do better, and what can be improved. So they're visiting several of our meetings, and so we'll see them around for different things for a while. Lastly, I just wanted to give you, we talked a little bit with customer service about some different metrics that we want to see there. We do provide from our IT team, rather our web team, the contacts that we get in. It's not a scientific compilation, but we just try to get as much information as possible to develop whatever sort of patterns of contact that we get. For the last 6 months, we've had about 911 views per day. So for this program, this specific program, so that's almost 167,000 views on our website for this program. The top reasons are how to apply for a contractor license, our frequently asked questions, forms, exam information, and how to apply for a technician registration. So you'll have the other outliers, and we have those numbers as well, but just trying to gather data. If we know that visits have been made here, and sometimes we can talk to customer service, and if they're getting a kick up in one sort of issue, then we have a conversation, and hey, maybe there's an FAQ that's needed. And we work within the teams, and we kind of try to get people to do self-service as much as possible. We want to provide that information and have it out there. So if you have any questions, I'll try my best to answer them, or I will pass them back to the new two Carlas and our Mike or Brian.
Dolores, any questions from the board? Thank you.
Okay, thank you.
All right, we move on to, make sure I'm on track, General Counsel.
Thank you, Chairman. Board members, again, Doug Jennings, Assistant General Counsel for the Department. Just wanted to fill you in on one particular bill from the last legislative session. House Bill 1342 could affect the program in just a few small ways. First, I'd like to, I believe it may have been Mr. Yelovic that asked the question. Forgive me if I'm wrong, but earlier during Mr. Medlock's presentation, there was a question about what happened if a person didn't pay an administrative penalty. Mr. Medlock explained that one of the options if a person doesn't pay a penalty is to revoke the underlying license. House Bill 1342 addresses this situation. So typically when a person's license is revoked, the law says that they have to wait 1 year before they may reapply. So let's say that you were assessed a $1,500 administrative penalty. Maybe you were unaware of it or you didn't feel like paying it, and your license becomes revoked. You have to sit out of the industry for a year. House Bill 1342 makes that a little more efficient, a little more effective, and states that if you have been revoked, if your license has been revoked for failure to pay an administrative penalty, you may reapply after either you pay that penalty in full or are in good standing with the payment plan made with the department. And so that means rather than sitting on the sidelines for a year, if you have a small penalty that you can pay in a lump sum, you pay it, you may reapply for your license immediately upon that payment. So you could save 10, 11 months. So it's a lot easier for people who have been revoked for that one specific reason to get back, at least to reapply. Now, of course, if the violation that was the subject of the penalty was pretty severe, that may have some bearing on whether or not your application is approved. But you at least, once you clear that penalty, you may reapply. Another issue addressed in House Bill 1342 is the restricted license. And House Bill 1342 allows our commission to issue what is called a restricted license. I'll explain that in a moment, in the ACR and electrical program. And what a restricted license is an alternative, kind of a middle ground. Often when someone has committed a violation or maybe has a criminal history, the options have been pretty binary. We can either accept your application to grant you the license, or we can deny your license or revoke or something like that. And this provides a middle ground. Let's say that someone has a minor criminal infraction in their past and may not, the commission, in their wisdom, may not want to grant a full license, a full unrestricted license. As you know, your contractor license, your tech registration allows you to go into the homes of anyone. Let's say you've got a burglary or some other offense on your record. The commission could at least issue a restricted license, which you could put reasonable restrictions on a person's ACR contractor license or technician registration. For example, to say you may not practice in a residential setting. You must be supervised in a particular way. And so those will all be decided on a case-by-case basis if the commission decides to go that path. But that is something that is an option moving forward. And once again, it's just in the air conditioning and electrical programs. And so there is rulemaking that is pending for that to implement House Bill 1342. And because it was just to comply with the statute, we didn't put it through our normal channels through the advisory board. Very rarely will that happen. But in this, we're strictly implementing the statute and not really needing any technical guidance on that. As you know, I would say 90% of the time we will bring rules to this body, but this is one of the exceptions. I'll just fill you in on the rule that we are promulgating. It's in the process right now. It just says that a person who is issued a restricted license must comply with the terms of the license. That's statutory. And it says a licensee shall use reasonable care to ensure that the holder of a restricted license subject to the licensee's supervision complies with any condition imposed by the commission or executive director. And I will simplify that by saying the law states not only do you, a licensee, have the responsibility to comply with the terms of the restricted license, but someone who is supervising you must use reasonable care to make sure that you comply with the terms of that restricted license. And so the last provision of this proposed rule says that performing any work, the holder of a restricted license must inform his or her employer of the conditions placed on the license. And so that is to make sure that a supervisor of someone with a restricted license is aware of the restricted license. And so that rulemaking is in the process, and we'll keep you apprised of that in the future. Any questions?
Any questions, board members?
Thank you.
Nope. Thank you, Mr. Jennings. So we move on to item G, recommendations for any agenda items in the next coming meeting. I don't have any at this time.
Well, I think, Mary Winston, TDLR, I think the board has given some homework to our E&E division, possibly customer service as well. So we will have feedback that was requested from there. If there are other items, of course, we'll have our reports and our updates. If there are other items, we all know that you can contact advisory.boards at tdlr.texas.gov and provide those items. The board members can contact Delia or myself and let us know that you have an interest in having some sort of item, and we will have updates from our general counsel's office as well. We are not currently, because the rule that Doug he's saying he's working on, is he's drafting and doing a great job, I'm sure, of drafting. We're in that process, but because it comes from the session, it is law, it's not requiring anything technical coming from our board. He's in that process, and it didn't come to you guys first. So we don't have anything. Typically, you'll get a couple of bites at the apple to review something technical, to get your expertise in that. This isn't that kind of thing. So we're not pressed to have a meeting right now. Internally, we're looking around January, but we always keep our internal models going. If it works or not, you'll never know. But we try to keep that running so we can stay on top of things. But we would like to poll the board. Delia will give a call, an email, to see what dates would be good for you. We're not looking at before the beginning of the new year. And so I just want you all to know, not before January. So she would be giving you a call a couple of months before an anticipated meeting to kind of get a feel of availability.
Dolores Campion, sounds good to me.
Okay.
Perfect. So the next one will be adjournment. So help me, I always kind of mess this up. So do I have a motion to adjourn the meeting?
Make a motion to adjourn.
Do I have a second?
I'd like to second that.
All in favor?
Aye.
Aye.